for example, and and this is knowledge that is non-codifiable per nature. So how do you codify beauty? You cannot protect beauty with a patent, you know, and pretty much of the made in Italy is based on aesthetic beauty. And yes, of course, you can protect the design, but and companies do that, but not through patents, with the exception of the engineering industry. I will disconnect
Yes,
a couple of minutes because I arrived home and I have no Wi-Fi in the garden, but I will reconnect in 2 minutes when I'll be inside my home.
Any other comment? If not, I pick up where we stopped yesterday, and that is this here is, do you see the screen?
Yes.
Good, thank you. So, so I was going through the parts that make a patent, and I will keep this brief because this is just for orientation purposes. This is not, there will be no exercise of patent drafting or anything like that. So just that you know, I have yesterday listed the main contents of the patent, and now I'm picking up on one of them, which is description. And this one should normally have the name of the invention which is claimed. Then it needs to have a field of technique, which is in which the invention is made. Also identified, and this is normally done by following international patent classification, although you can add and describe in a sentence, you know, what it really is, besides picking on a class from international patent classification. So this is similar, if you remember when I said that there is NIS classification in trademarks. The difference is that in patent, this classification is used for purposes of helping examiners. It is not legally constitutive as to the scope of the right. So even if you identify a classification narrower than the scope of the patent itself, it will still be valid out of what you have identified. With trademarks, it is not the case, and please remember that in trademark, whatever you describe in the classification defines the scope of the trademark, and you will not be able to extend it later. You can't extend it in the patent, but if you don't name it and you describe it, it will still be part of the scope of your invention. So normally also you describe what kind of a solution to a technical problem you are disclosing in that patent. In order to help examiner further, you describe the state of the art, meaning that you list even individual patents related to your invention in a systematic way. You also refer to scientific articles that are close and related to your invention. Then you describe the invention. Then you also explain the drawings, if you have any, and their relation to the description. And then you provide a best mode for practicing of the invention. This all helps examiner understanding what you will be claiming in the claims. And you point to industrial or any other application of the invention. So this is what you have in the description. Yes? I thought there was a question. Anyway. So when the examination starts, what really happens is a process that is similar to a negotiation with your examiner. You try to persuade him or her to grant a patent if they are reluctant, if they hesitate. And they may raise the objections based on novelty and on inventive step, most likely. And then you try to show them why they misunderstood what you have described, or why actually there is something additional that is to be pointed out, and so on. Mind you, you cannot add to the description after you file. So you have to have a broad description in order to be able to say, well, this is in the patent and I can change the claims because it is in the description. And so together, working with the examiner or negotiating with her or with him, you come to a result which should be a patent grant. So as I said, it is important for patent description to contain all the elements that will allow modification of the claims. There is also possibility to use the US provisional patent application, because there even the claims, it can be changed to a greater degree. So you can get another priority, and if you apply very early on, one of the tactics is to use this flexible US provisional patent application. Then keep in mind also that when you apply into the PCT through the dialogue with the International Search Authority, which will conduct a preliminary examination, you will have an option to negotiate with them and do so-called central modification, or defer this and do it on a national level. Obviously, when you do it on a national level, you multiply the cost. Yet, when you do central modification, it may not be satisfactory to all the national offices that will come to examine your application. So everything has its own pros and cons. There is this, in many countries, as I have mentioned, we have a patent and then we would have a utility model, and then there is a possibility to apply but without substantive examination, but I'm not going into that. This is just one other element to keep in mind, that you will be able to defer the examination to a later stage after the grant of this small patent that is offered in such jurisdiction. This is in greater detail what I have already said. Here probably I should only say that these smaller patents are normally shorter in term, and normally that is a 10 years length of the patent. And I have explained yesterday also that a patent will cease to be in force if you don't maintain it. What is important to know is that almost universally in all jurisdictions of the world, the annuities will be progressively increasing. So you have like an exponential growth in many countries, where last 5 years are growing very much, and a single year of maintaining can be like 5 first years, you know, or even more. It will become more and more expensive. So you have to have a good commercial reason to maintain the patent in force for its full duration of 20 years. Here we have just as an illustration a patent document from the Croatian Patent Office, where you can see that it has some formal bells and whistles. You know, it is decorated with this tricolore croato, which I don't know if Italians put the tricolore on their patent where the green is instead of red, but and then there is the water stamp and the regular stamp and all the you know, bells and whistles that administration uses to impress us. And then within this hard paper cover, then you have the document itself, where you see some elements. Up here is the patent classification. Here are dates of priority, dates of extension. Here are the applicants, inventors, and representatives. Here are some related patent applications derived from this one, and here is the abstract, which I said most of the people will be reading the abstract first, but those who really know patents will jump immediately to claims. And I deliberately chose one short, simple mechanical patent, which has here a description, as you can see, and it has these elements which I have identified before. And here you have patent claims, a nice, concise 4 claims, of which which I don't know if they are, yes, they are independent claim number 1 and 2, and then 2 dependent claims, as far as I can see, 3 and 4. So keep in mind that the claims will be written in the format that is independent or dependent, and dependent claims are used to further specify something specific to to the invention, but not necessarily at the core of what the invention is, which will be in the claim number 1 normally. And then probably some kind of a secondary use of patent or a method. If you claim at the same time a product, a machine, or apparatus, it can be in the claim number 1, and then let's say there will be 9 dependent claims, and then claim number 10 will be a method, including that apparatus, which will again be independent with its own set of dependent claims. So these are the ways, a little bit, of how things are drafted. Then there are drawings. There are many formalities with the drawings. Can you use technical, they're not identical like technical drawings that you produce for manufacturing or something. And then there are how you number them, how you mark them. This is normally described in the guidelines of the patent offices of a national country, and they are now pretty standardized, at least in Europe. So under the European Patent Convention, as I said, we have one single examination for the entire territory of the signatory convention, and they will give you, like any others, it's just the same but better than the others. It's really one of the best patent systems in the world, together with probably US and Japan and China and Korea are normally listed as some countries that have a very good patent systems, but there are others, mostly those that are international search authorities for PCT. They are all serious offices with serious procedures and serious guidelines. There are terms for a reply, so that the procedure develops at a certain pace, which is predictable and which how long it will last, which does not prevent some patents from getting granted after 1.5 years and some after 6 years. That is connected to that and talking to Italians, I don't know if you have heard, Italy was famous for many years, and now Italian Patent Office caught up somewhat, but because of the slowness of the procedure, there were so-called submarine patents. The Italian submarines, or some call them even torpedoes, they were, because of the slowness of the procedure and many formalities they were surfacing later. So if you had the first application there, it would come to the surface and be granted many years after. So this just shows these differences that you have all over the world with patents. Yes, you then get the grant if you persuade them that it is. One of the features of that procedure is the patent opposition. Not all countries have this worldwide. They rely just on examination, but here we also allow for opposition. It kind of increases the hygiene of the granted patents. There is a chance for interested parties to oppose a published patent application, so you can appeal even the decision about the opposition. And in the first instance, it entails filing an opposition. It entails the patentee's right to respond with counterstatement. Then there are further written submissions are allowed. Then there will be most likely summons to oral proceedings where the board will listen to the parties' arguments. There will be proceedings themselves, and there will be a decision, and then this can be appealed. And on the appeal, again, you will have to file it. There will be a chance to respond. There will be, again, further written submissions, oral proceedings, and a written decision. And here there is a chart, which obviously you can't read, but you can find it on the website of the European Patent Office. And it's a flow chart that describes the flow of this procedure. And here we are on the next chapter. Are there any questions regarding patents? I don't hear any. So I'm sorry, I have to drink water. I already had the meetings before our lecture, and it's already the third day that I'm speaking, so I apologize. Here is next chapter on business secrets and confidentiality. And over the last year, it got a lot of attention in the EU because EU enacted a directive on business secret protection. And this follows the general principles of US trade secrets. You know, US has always somewhat different terminology, and the business secrets, what we call business secrets, they call trade secrets. We will here look at some practical aspects, a way of protecting it. We'll look at NDAs, which I am sure all of you know by this abbreviation that stands for non-disclosure agreements. So what is business secret? Again, as we always try to define in every right that we look at, what is the object of protection? And very often here it is said that it is a secret information. So mind you, it must be secret. Something that is not secret cannot be declared a business secret. It must be factually secret. And it needs to have a market value. So not any secret, you know, is protectable as business secret. It needs to have a market value. And most often, this will be technical know-how, where you can have some ideas, you know, unlike in the other IP rights, formulas such as the Coca-Cola recipe, the most famous trade secret in the world, or a process conducted in a certain sequence. These things can be kept secret and will be treated as business secret by law, by legal system. There are other market value data, such as business strategies, marketing campaign strategies, customer lists, suppliers lists. You know, there will be many. In pharma industry, there is an additional format called data exclusivity, and this is also for chemical preparations in agriculture, which has a formal regime of keeping when you apply for permissions to market a certain compound. This formality of labeling, probably it would be better if I have written here of marking, because labels are also have legal value, labels on the products. But here we would talk with intellectual property, we call this marking. You know, when you have the or in copyright notice or patent pending or patent number, you know, these are all marking. We call them when they are on the products. Same thing must be with secrets. So if you have a document describing that what is secret, it must be marked as confidential. And also to whom that confidential information pertains to, the name of a company. No? It is important to have bylaws. Again, the role of the soft law here is very, very pronounced. And I can tell you that in Croatia, there is, again, specific problem with business secret. You know, Croatian businesses complain that they cannot use patents because they are so expensive and so complicated, and it's not for them. Yet, they don't use business secret protection either. And why is that so? Again, it is part of the business culture where secrecy is not respected. In Croatia, you have leaks, and not only in business, but all the time. Everyone shares information non-stop. And in order to maintain secrecy, a discipline is needed and formality in marking. And again, Croatians are not disciplined and not very formal. And then again, they miss opportunity to protect business secrets on time. And then the employee goes away without business secrets being protected and starts using it, you know, and it's gone. It's gone. You don't have any more business secret protection. So it's quite painful. I have to tell you, you know, for me that I'm now 30 years watching this, you know, it's quite painful how slow it is. Again, I am not unhappy because the changes are huge and the trainings like this help a lot. But what I have seen, the leaks of high technology information, because yes, Croatia has also high technology companies, you know, and what I have seen, you know, I wanted to tear my hair out, you know, of the errors which were done unnecessarily because of this business culture which I have described. So you need to have bylaws determining how the system will work. You need to have provisions in labor context and managerial contracts. So employment and managerial agreements must contain this, and there must be marking on all of this. when you have contacts with the suppliers or designers or any kind of outside contributors to your projects, you need to have non-disclosure agreements concluded with them, because they will learn by intention or by chance. They will learn your company's business secrets. And this is also another way to lose the protection if you don't do the right non-disclosure agreements. The costs for this are low. We are talking about few thousand euros to have this, what I have now listed above, the bylaws, clauses in the agreements, and marking. We do this as a matter of routine. I mean, lawyers, no? This is not a big science, so to speak, but so it's not too expensive. Although there will be situations of non-disclosure when you will have a very complex, tailor-made agreements for a certain situation, which might, be almost like these American agreements, 5-6 pages with some exclusivity rights to the person who will evaluate. For instance, when you submit technology for evaluation to someone, you give him a non-disclosure agreement, but you can, in such a non-disclosure agreement, you can agree to a period of, let's say, 4 months, in which that person will be the only one that will have the right to evaluate this technology, and you will not be offering it to the others before the exclusion. And then you regulate what happens with the documents that were submitted, what happens with the all electronic data and things like that. So you can go into quite great detail in such agreements, and they will obviously then cost more. The one drawback with business secret protection, which now was addressed by the European Union through the directive, is that we had a higher degree of non-harmonization in different jurisdictions, and you didn't really know how will the local courts react to your request to be protected under trade secret, in spite of having quite a long. For instance, Yugoslavia had business secret protection already in place from the 80s. Yet our businesses, even before the breakup of the federation, as well as after, really behaved as they have never heard about it. It's very strange. And funny enough, this Yugoslav introduction of business secret was done to facilitate the transfer of technology from developed countries to less developed countries, which was one of the topics of a non-aligned movement. And we had the licensing provision. Yugoslavia was one of the first countries in the world that had a licensing agreement, as what lawyers called named agreement, in the civil code. In our code of obligations, we had the licensing agreement before most other countries in the world had it. And in the same package, we had the business secret protection, which was supposed to protect the recipient companies from the companies that were licensing the technology and would presumably learn things. However, as I said, this was quite ahead of time, really, and the business did not start using that. And now, obviously, on the EU market and with the EU directive, things are turning around, and people are thinking about business secrets in another way than in the past. I don't know how is it in Italy, really. I did not encounter, I did not work on the cases with business secret during my time in Milan. Here we have this more information of the EU. This is this directive of 2016 that I think came into force 2 years ago or something like that. it harmonizes the definition of trade secrets in accordance with existing internationally binding standards. I mean, read US, you know, that's internationally binding in a way, because they were in all of this field of intangibles. US was there before the others were. And this is also why the licensing agreements in Europe look like American licensing agreements, having this long form, having the preamble, you know, all the structure of this is taken from the market that had a much longer experience with it. This definition defines relevant forms of misappropriation of, you know, and clarifies the reverse engineering and parallel innovation must be guaranteed, that protection must be, which is also another difference between the countries, because not all were giving this additional forms of protection. Yes, it's not an exclusive right, because once it's gone, you cannot exclude anyone, although it was yours. So these are, it behaves somewhat different. So keep in mind, it's again like copyright. This is not a registration right. You don't go to any office, patent office or such, you know, to get a business secret. You have to implement these elements, bylaws, clauses in labor, in employment, and other agreements and marking. You know, this is what you need to do to keep your secrets secret. And so on. I'm not going here into detail further. You see, again, I insist on this, based on this, what I said is a painful Croatian experience, because people kept things secret, but didn't have bylaws. You know, many companies that would be certified with international standards, such as ISO 2000, not 2001, I think, but 2007 or whatever. I don't know now which standard introduced also a need to have a system to keep things secret. Such companies discovered that they had system in place once the breach occurred. It's funny thing, they would get the bylaws and the clauses and everything without knowing that they are doing business secret protection. Really, they were doing that for the purpose because consultants were telling them, you need this to be certified for an international standard. And then when the breach occurred and the lawyers asked, do you have bylaws stating the rules of how the secrets should be maintained? And again, you know, what is written in the bylaws? For instance, just so that you have a clearer idea, the bylaws will say, we have 4 classes of secrets. Class A will mean the secret that must not be divulged even within the company. Only such and such members of administration of the board will be able to access it. You know, that's the Coca-Cola recipe. You know, only 2 people or 3 people have access to it. Class A2 will mean the whole board will have access to it. Class A3 will mean that the board and such managers will have access to it. Class B2 means that it can be taken out, but only as a paper document mark, not as an electronic document for sharing. Class C will mean such and such. So this is what it is described in the bylaws. And companies need to control the implementation of this so that it is in accordance with what is determined by these bylaws. These bylaws will also request that trade secrets are written and marked. because this enables us to determine which data constitutes trade secret. So those that will be identified in such documents will and marked as secret and maintained in the regime of secrecy will have legal protection. If you don't have this, the judge will say, I'm sorry, you had to obey these formalities, you didn't, no protection. Your former employee has a right to use this. So again, you need, in order to manage this, like managing all intangibles as part of the strategy, you need to have them identified and track them in usage, in how they are used and how are they divulged and to whom and under which conditions. And then you can show to a court that you really cared about your proprietary information in an appropriate way. Normally, this also would entail a person or a body to supervise these trade secrets. So this is similar, like on the patent side, where I have said that you normally would have a committee determining whose invention will be patented. I don't remember if I said this or not, but these criteria with patenting must be very clearly, transparently made available to all, because very often it's a question of vanity. You will have I think I mentioned this, but I will repeat it. You will have an inventor who will say, why you didn't invest in my invention? It is patentable. We have determined this based on a search, Yet you had protected my colleague's invention, which, of course, in his opinion or her opinion, is not as important as this one. So again, you need to have bylaws, and you have a committee that kind of determines what is fitting to the bylaws. Here you have again this, and you will monitor which persons will have access and who will have a right to disclose them to the others and so on. You will also be able to prescribe in more detail the obligation of employees regarding the retention of such data, how they have to care for them. Again, can they keep them on USB sticks? Can they take the USB sticks out of the office premises? Things like that. And there will be sanctions for unauthorized disclosure or exploitation of trade secrets. Then the extension of protection through employment and managerial contract clauses. What happens after person stops working for them? How do they have to return things, documents, data that is connected with the secret? And there must be trainings, because people don't intuitively adhere to such a formal way of protection. So you need to do awareness and training among the employees of why is it important, and how do you disclose them? How do you keep disclosure limited and things like that? Of course, this then will lead sometimes to licensing agreements. So they have to understand, licensing. So they have to understand how will a disclosure be transferred into a license. So these are all things that we need to build within a company in order to use business secret protection successfully. Here, one example of protection, it is by civil law, and here you see that unlawful obtaining, you know, what they call stealing of a secret. No, you go as a spy or breach a firewall and take the secret database is certainly unlawful. And then how you use it, how you publish business secrets for others, for other people in the company to use, and all this can be done illegally or be breached in some way. And then you have to go to the commercial court in Croatia. We have commercial courts, and you will start a litigation about this infringement. You may seek an interim measure or a preliminary injunction, as common law lawyers have it, misura cautelare in Italian, and you know. But keep in mind, for instance, that unlike other IP rights, when you have injunctions, these interim measures, in the law on patent, in the law on trademark, they have their own interim measure provisions. The business secret does not, and you have to go to the General Enforcement Act, Act on Enforcement, to seek general preliminary measures, and this will be different in court. It will have a lesser degree of urgency, which was not the intention of the legislator. It is just, you know, that we have such holes, you know, in our system, and not everything is treated consistently. So it might be slower to get there, and so on. You will have a right to an action in finding of unfair trading as well, in parallel. So this is not only violation of business secret provisions, it is also unfair trading. Unfair trading is determined by law on trade in Croatia, and you will have this parallel cause of action, because this is inherently unfair to use someone else's information. So even some non-business secret information under certain circumstances will have the unfair trading cause of action available. So this is also important to know. You can ask for a prohibition of similar treatment in the future, and compensation on damages according to the Civil Obligations Act. I'm not sure, this might even be the slide. I'm not sure if this has changed, but we are not here training lawyers. This is just that you have a general idea. Laws change all the time, and it's hard to keep everything updated at all the time. Violation of personality right is something that was introduced in Croatia some 10 years ago when we reformed the Code of Obligations, and personality rights was available to private persons, physical persons, but then it was extended to legal persons, and you can seek violation of personality rights, such as damage to reputation, for instance. This is an extension of kind of damages you can ask. In many countries, these procedures will be done by judges that are less specialized, because it's not IP stricto sensu. So it will be assigned to the general commercial judges and not those who understand intangibles, which will make them rather apprehensive. In many countries that were, the new countries of the EU that were non-market economies, for many years we had problems, really, until 10 years ago, with the judges who were very unsure of what they should be doing when they had a claim for protection of intangible assets. And they were postponing the hearings in such situations, and this was really an additional burden when you wanted to use business secrets. In the past, some of this is still around, you know, and I don't know how this is in Italy, or do you have this kind of discrepancy, unevenness with IP as in Croatia? I was, for instance, once I heard a case study from Finland, which was incredibly similar with facts, totally comparable situation. And in Finland, all the actions, the seizures, everything, the initial actions, the preliminary measures were done within 3 weeks. In Croatia, it took 3 years for approximately the same. And the case went to the Supreme Court and back and lasted, I don't know, like 14 or something, 14 years. You know, so this shows you how difficult for the companies might be to use these less straightforward protections, you know, that are somewhat more marginal, although they shouldn't be. There is a criminal law protection as well available for so you know, this is really amazing, you know, when Croatian professionals hear that there's a criminal act of violating someone's trade secrets, they normally don't believe me. It is so out of our culture that they just don't know about it, never heard about it. You know, and there are relatively few cases, and they are not widely publicized, and this remains below the radar screen of most people in the business. So, as you can see, business secret protection, as other IP rights, requires discipline, and here it is even more pronounced, time, knowledge, employee resources, strategy, and budget. And if you don't have this, you will not be successful. So people who use IP system to their satisfaction fulfill all of these requirements cumulatively. They have all of them covered. So the company must be prepared for complexity of patent protection. And for instance, it is difficult if you have a small company and you don't have patent specialists. It's very hard to be prepared. But I will tell you how I prepare Croatian startups. I tell them, look, first, don't start doing IP protection before you are funded, because you will bleed. It is too expensive. Even with the startup fees, which my firm gives to the startups, you know, it's still expensive. So don't rush ahead. Take the information in the company, start structuring them, and prepare for making a strategy. Once you get funded, start implementing the strategy in terms of protection and start planning for enforcement. So if you don't follow this gradual approach, you are likely to die under your own weight. It's a suicide for a startup to start using a patent system, for instance, for a litigation. It's just not possible, you know, it's not possible. before you are funded to engage in and already getting a patent is very hard. So there must be steps on the way of getting there. But once you are there, it is very powerful. You know, people who know how to use patents have a huge advantage over their market competitors. And when you have huge market competitors, you have patent wars of the complexity that is mind-boggling. I mean, you know, the strategies when two giants collide and start playing the judicial tricks on each other. I mean, this is just, it's, you know, when I start telling stories about this, you know, people just look at it. They never heard really how true patent wars are conducted, you know. And obviously, having studied in the US and worked in the US, I have heard first of these stories in the US. And I remember on the summer semester that we had on my postgraduate degree, we had the practical classes. And there was a gentleman who was head of patents at Caterpillar, you know, at the big, this bulldozers and all kind of rolling machinery manufacturer. And they were very far ahead. They had the big R&D budget, and they were, you know, very innovative and were protecting a lot. So they had a lot of competitors as well, such as Komatsu, for instance, a Japanese company that was competing. And at that time, Komatsu didn't have so much basic research and applied research even as Caterpillar. So they were very often following the patents that Caterpillar would do. But they developed a strategy that they called in a nice Japanese war language, they call it encircle and strangle. So what they would do is when Caterpillar went out with a new patent, they would then make inventions, genuine inventions on top of that patent, improve the state of art, have better solutions based on this underlying pioneering patent, and would have like 10, 15, up to 100 patents just to encircle and disable, don't strangle, that's why they call it strangle, to take the breathing air away from Caterpillar of applying their patent in the best possible way. And obviously they were suing each other, and Caterpillar was trying to cancel the patents which they were filing, and this was just like a huge snowball, which required gigantic budgets all over the world, you know, and things like that. And I work a lot with pharmaceutical industry, and the things that are happening there, and how you extend patents by filing the second use patents, or filing a patent for improvement not of active compound on which your patent expired, by a novel way of amalgamating fillers to the active compound and getting a smaller pill or whatever, you know. So these things are just endless, you know, endless patent tricks being played, you know, against competitors as we speak, if you will, you know. And I work for both originator and generic firms so the patent strategies are obviously specific to the, although as these two scenes merge, there is more similarity nowadays than it used to be before. But determining which patents are vulnerable in which way, you know, the resources that are spent on examining the vulnerabilities of the existing patents, just mind-boggling, you know. And small countries are really having difficulties to keep up. It requires big budgets. It requires big patent departments. It's impressive, I have to say. You know, sometimes. Again, I told you, you know, the Americans said in the 50s, if we wouldn't have patent system, it would be irresponsible to introduce it. And as we have it, it would be irresponsible to abandon it. So we are stuck with that beast but who knows how to play it has a huge advantage. And I always tell people, you may have your opinion about it. You may be reserved about the benefits of patent system. But if you want to make money, there's only one way to go. Use the patent system, you know. So that's where we stand with it. Unlike patents, you know, with business secret protection, you need smaller financial resources, but almost bigger human resources. But this is not entirely correct. But it's really a small financial resources, and you know what happens. You know, so ideally you will start with trade secrets, business secrets. But some products can be reverse engineered, meaning that once you put them on the market, the competitor buys a device that you put it, see how you do it, and reverse engineers it into their own solution. So there, it's not your choice, will you keep something secret or not? You know, with Coca-Cola, which is such a good example for business secret, it's impossible to reverse engineer it. Although people tried, and you have all kinds of Sky Colas and Pepsi Colas and others, but no one really was able to replicate identically the Coca-Cola recipe, because it apparently has dozens, if not over 100 compounds, you know. So that's very hard. If you have dozens of compounds, to put them together in the right proportion and in the right sequence, you will never get with certainty a result that will be identical to the original trade secret. But if you have a machine that is in a box and the consumer doesn't see how it works, but when you open it up and you see how it works and you are able to replicate, then there's no then by doing reverse engineering you can kill that secret. So there will be industries that will be able to keep the business secrets, but the others will be not. So those companies that determine that they can keep their business secrets, and I mean even those which will not be able to keep the business secrets on the products, will still be able to keep the business secrets on the list of suppliers, partners, and so on, customers. So you will always have something that you can keep secret, but there will be a lot that you won't be able. Still, you need to protect it and start monetizing that value of the secret, whatever it is, the entire thing or just the partial thing that you can protect. And use that money to build your patent strategy, and then be able to identify those patents that are most promising commercially and go for their protection. That is the path that the SMEs in Europe need to learn, or need to take, or need to practice. That's the way how this should be done. It is very hard to jump in the big boots of a true patent player. So start with business secret first and then move into patent. Obviously, if you are a startup, you need to identify patentable things initially so that you know that you have them. And you must keep them secret because you don't want to destroy your patentability of your invention by talking about its crucial features on a fair or even by offering it commercially. You will destroy its novelty because once you start commercially offering your invention, you will not be able to patent it, or even if you obtain a patent, because it will not be visible to the examiner that you have offered it. The party to whom you have offered may be able to cancel your patent and show that they were paying you after the offer for using of that thing before it was protected. And there was no business secret, you know. So one must be rather careful in structuring this transition from a startup to a patent game player in the end. And one needs to have patience also, because it doesn't come overnight. This time is normally measured by years, if not decades, really. Again, don't be scared by this. I see over the last 24 months a huge change. You know, the companies that are coming to me in the field, for instance, of artificial intelligence, where I am very active, and now, you know, who are startups, yet who have a very clear plans of how will they build their patent protection policies. And you know, they already know before we start working on the first patent application, they know 2 or 3 of the next one. They know in which time rhythm of time, every 3 months or every 4 months or every 6 months, they want to file a next patent application and so on. So things are moving. Again, I'm speaking locally rather than for the both countries. Here, who knows what is this? That's easy. I mean, that is what you see. What is this?
A train.
Train. That's correct. And what kind of a train is that?
High speed. And...
Yes, I think this is electric, but it also exists in the diesel version. It is a product of a Croatian company called Končar. And this one on the picture was delivered to the Bosnian railways, and it's left unused and unfortunately unpaid. But the Croatian railways bought a lot of these trains. This is not a true high-speed train like Pendolino. In Italy, this is some kind of a medium speed, and it has the same this tilting technology, but it is very nicely designed. In my opinion, it is also you know, technically advanced with the technology from bought outside and with technology developed inside. So, for the purposes of exercise, we can say this is a complex high-tech product. What do we do of what we have heard over these days? You know, what do we do to protect? What does this company need to do to protect this train? Let me hear you a little bit. Anyone?
Mladen, sorry, I was answering to an urgent email. Can you repeat the question? Sorry for that.
That's very kind, Guido. I would like others also to participate. The question is, what kind of steps would you devise to help this company protect this product? What would be the measures of protection that you would be deploying? For instance, if you would be a lawyer, company lawyer, put yourself in the shoes of a company lawyer. And
but the main advantage is technological. The main competitive advantage, I mean.
I will answer circumventionally. The example is here because it is a complex product that has all kinds of features. That's the, you know, it has all kinds of features, even basic to high tech. So what is all that we have? This is in a way repeating of what we have said over the last 2 days.
But for the technological part, patenting for the design of the of the product, industrial design. But I'm also a fan of open innovation. So
you see, so this is not only Croatia. Yes, I understand you.
I have a question.
If I want to become a standard, I would cancel any patent and give them for free, like Tesla, you know. But in this case, there is no role of standards, I think.
Here the company must make a profit. So what do you do? There was someone who had a question. What is the...
Well, it's more philosophical. Maybe it's how do we manage to balance, in a sense, the paradigms of patent protection and open innovation?
Well, I am ready to answer that. This is more of an advanced question in respect of the one before you, but it is more interesting, and it always enables us to think additionally even about the basics. So, you know, the open patent philosophy was articulated probably some 15 years ago. There was a guy, I forgot his name because it's a long time. I think his name was James Love, who wrote some books about the pros of sharing the knowledge rather than keeping it exclusive. So the traditional view is that, and this comes out of the US Constitution, they say that they give protection to intangibles in order to stimulate development of useful arts, meaning arts means technological arts in that sense, you know. So they want to stimulate technology, and the philosophy at 200, what is it now, 230 years since the US Constitution, this was prevailing technology and philosophy behind the intellectual property. If you want to increase the production of intangibles and innovation as being one of the important parts, you need to give an economic incentive. So there was an idea that if you don't create the monopoly for people to earn, there will be less economic incentive. So this is what we had with IP for 230 years. This has been started to be questioned 20 years ago, 15 years ago, although there were before also, you know, there were different phases. IP always goes in waves. It decreases and increases. When you look historically, there were periods of anti-IP in the US as recent and as the late 50s and early 60s. The Supreme Court had 2 judges who were anti-IP. Justice Douglas and Justice Black were against IP, and they were undermining the IP protection. So you had always ways of looking different at intellectual property. Well, now there's something where I will answer philosophical even to a greater degree, not practical at all, you know. Since we have digital domain, everything became inherently shareable. Digital copy is identical to original, and it can be multiplied indefinitely. So this inherent multiplicability of products in digital domain, and mind you, we are digitizing ever bigger chunks of our material reality, you know. 25 years ago, music was a physical thing. It was an LP. Then it was CD. Then even when the modems came, it was impractical to upload the song because it would last 40 minutes and the entire CD would last for 3 hours or 5 hours. But then the Ethernet and the internet connections made it possible to do it in a minute. And the movies, which were before only possible to see them first in cinemas and then at home over the VHS and Betamax video cassettes, suddenly became also shareable. Yes, it took 3 hours to download the movie, but when we got broadband, it became very short, just as the case with music. The funny thing is that we did not stop there at all. So these things that we saw as physical, namely musical, films, became digital. Now with 3D printers and the fully printable sports shoes, we have the same process of having sports shoe going from the material reality into digital domain. And it will not stop. So this technological civilizational shift calls us to re-examine the basic premises of intellectual property protection. Without now elaborating further, and I wrote articles about that, and you know, this is one of my favorite topics. I have a 4-hour lecture which I do for law students, where I elaborate this, what I told you now in 2 minutes, I elaborate in 4 hours. But this process really, as our creativity changed from this idea, I will repeat, the idea that there is a gifted individual that gets inspired on extraordinary moment, and we have to protect that. This is in copyright, to the idea that we are creating new content as a routine by any individual based on the knowledge and the certain procedures that we have as a part of the system of making intangible added value, you know. So this creativity from something almost like a divine became just an economic added value. So this, together with digitalization, leads to your understanding that there's something wrong. However, if you do business, we still did not resolve these challenges that come. And I can only tell you that if our societies want to make money, we can not yet abandon using the old system. So you might be in favor of sharing knowledge. You might even see that it speeds up development. Yet the investors who will turn your knowledge into products will still require obeying the rules of the traditional IP protection. And that's where the buck stops. That's the situation nowadays. We need to invent models of sharing so that we maintain the well-being or wealth of our societies. And that's the challenge. And I am asking now you who asked the question and the others, what can we do to change this paradigm? I'm asking because I don't know yet. I want to propose this to the policymakers because I am in position. I have been lucky in my career that I'm still active and yet already in the position to influence international policy, making. And I speak to World Intellectual Property Organization and to the EU IPO and so on. So what do you think? What should we be doing in order to be earning wealth by exploiting knowledge and increasing it? Any ideas? Is there anyone who disagrees with that, or anyone who has an idea? If not, I am going back to this train, and I will tell you that, this case study would normally, I'm not at liberty of disclosing, what is protected, what's not protected, but it shows that the companies that are able of high technological solutions and of making a very good product are not on the same level in using the IP. That's one of the lessons which I have learned by working with this company. This product and the point that I have here, which is the point of this exercise, is that in the end, we need to use all intellectual property. Every one that I have mentioned, except probably the geographical indications, should be used here. Think only about the software. You may know that Croatian high tech in the battery field is so high that Lamborghini is buying Croatian battery management solutions. So people in this company, they have very advanced algorithms for transmission solutions with trains on the poor tracks, which are the case in the Balkan countries, and things like that. So there are very advanced, specific knowledge that can be. Should it be protected by copyright? Should it be protected by trade secret? What this all needs to be, and think only about the poor lawyers in there. How many hours they will need to spend learning about the project, explaining to the engineers what should they tell them, what is relevant for determining what is protectable. Thinking about when the design, was this design made in-house or outside, as it was the case apparently, So this is an excellent train design. It looks better than 95% of German trains, in aesthetical sense. Just like Italians, Croatians, here we in the South have this feeling for aesthetics, and it turned out to be a nice thing, which is not overly aggressive, How do you protect these things? Here you have these oval shapes being repeated. Do you convert this oval shape in some kind of a trademark sign that you will be protecting? Besides design, tons of questions, years of discussions to be able to fully protect such a complex product with patchwork, and that's the key word here, with the patchwork of IP rights protection. Because unless you use the patchwork, you cannot ideally protect. There is no protection available for such a complex product. It needs to be kind of, patched together, all these little bits and pieces, and done that. And how many opportunities might be missed on the way? That's another question. So here we go. That is, I think, that takes us to the end of this block. Do you have questions?
I have a question. How long would that protection last? We talked about, I think yesterday, that it's only for 25 years, or could it last longer? How does that work?
25 years is for design, 20 years for the patent.
Okay.
Life of the author plus 70 years for copyrights. So each right will have its own duration. You will need, as someone who will be keeping track of the rights within a company, be it a legal department, be it some kind of a dedicated intangible asset management department, you will need to have a database, or at least an Excel sheet with all this duration. And then the licensing deals, as you can see here from my slide, we are going to talk about this next. All the licenses that you have taken in where you acquired the knowledge, or the licenses that you gave out on your rights, this all needs to be tracked. Otherwise, you are lost and you will do a mess of business, So this needs to be systematically tracked. You must know when the rights will expire. If you have a patent that needs to be renewed every year, not renewed, extended, the annuity needs to be paid every year, you need a database that will have an alarm a month before, so that you instruct the agents in other countries to pay the annuity fee. You must budget this. You must know how much will you spend next year on this right in particular and all the rights together. So it is very demanding. For instance, when we work with the clients, we have a very developed, this is called IP rights management database, where we allow clients to access it from outside of our organization. And they don't have to build one for themselves. They will have access to their own rights in this database. And, I think many companies came to the same conclusion. Over the last 5 to 10 years, the trend was to keep this knowledge in-house. So the bigger corporations stopped using agents to keep track of their licenses. They were tracking them in-house. But you need to have this, and there are giant databases. I'm not talking at all in this training about this practical aspects, but you have existing products on the market that are specific for patents or trademarks or so on, you know, very, very sophisticated and developed products. Same like, for instance, with searching, you have a number of private databases to which you can subscribe and do the searches, initial searches individually and so on. And does this answer? I gave you more than the question was.
I have a question also. I agree that you need to manage the IP rights that you have and have some sort of legal department or some person in the company responsible for that. But for a startup, maybe that's hard to afford, right?
Yeah.
So how can you deal with that? Can you hire them as a consultant outside? And if
Yes.
so, how do you guarantee that they won't share the secrets with other of their clients? You know, you need
Yes.
to write also a confidential agreement with a lawyer, but they are the lawyer, so.
No, with a lawyer, you don't need confidential agreement because the lawyers are
Bound for that.
by force of law, lawyers must keep confidential whatever the client tells them.
Sure.
So there is no need for a confidentiality agreement with lawyers, but many companies will ask you nevertheless to sign a confidentiality agreement, and especially non-sophisticated ones. So the smaller companies that don't know that lawyers are obliged by the force of law to keep things confidential will ask, and we always sign. You know, we have hundreds of non-disclosure agreements signed with our clients, but the bigger clients usually don't require this because they know that especially the bigger law firms, you know, they know that these people are professional, that they know how that they have to keep things secret. What I have described before in respect of startups is that if startups starts playing IP protection game, and especially enforcement game, before they are funded, so before they have received investments, when they are bootstrapping with the friends, family, and fools, you know, this is the triple F, friends, family, and fools as investors, there's never enough money for IP. And it might be a suicide for a startup to start doing IP before being funded properly. And I have said already that in that situation, you need to take advice, ask for some startup discounts, and, you know, get oriented, start developing your IP strategy, and when you get funds, develop the strategy fully and implement it. So this moment of funding, of receiving proper funding, is pivotal for startups, and this is why you have good incubators which will teach this. I am mentoring startups in many. I'm now by my, I think, fifth incubator where I am a mentor, and we teach them how to play this game. I hope this answers your question.
Yes, thank you.
Yes. Good. I took 5 minutes of your break, so we will extend it just a minute or two. I'll be back in 10, 12 minutes, and we are going into the last part of our session today and of this training. Thank you very much.
Okay.
Thank you. See you.
Okay.
Hello.
Hello, I am back. Any questions before we start?
Ciao, Mladen. Sorry, I received an important call from a company in the last 10 minutes, so I switched off.
Okay, but I understand that this is recorded, so but there is nothing so important, you know. I kind of do little circles, you know, repeat things I have said before, because as we are getting to the end, it's in order to repeat, so don't worry. Any other question before we start? Let's go to licensing. According to our schedule, this was part of the last block, but it is actually equally welcome in this last block, which is in a way, this is more legal stuff, not licensing, but enforcement is, and we will not spend too much time on it. So there's no problem to deal with licensing here. Licensing is primarily a business endeavor. And what I want you to take with you is best encapsulated in the translation of the word licensing into plain language. And the way I would translate licensing, what is a license? License is a permission. You permit someone else to use your IP right. So it is best understood in this most simple way. So when you have a licensing agreement, it's an agreement about the permission for someone to use your right. And you can transfer the entire right, or you can transfer its component of exploiting, of an invention, or practicing of an invention, as they say. Or it could be a technical knowledge or even experience, you know, if we are dealing with trade secrets, or a trademark, someone to use your trademark, industrial design for a fee. This is a consideration, as common lawyers say. It is a consideration. It's a counter prestazione, no? The something that you perform in return. So there's a fee for permission. And it is very important because it multiplies income. So even if you don't use it, someone else might think it is important, and they will be paying you for using that right. It is also important because it permits and promotes expansion of technology. Technology that someone developed will be used by someone else. And if we connect with what we were saying in the last block, you know, as the whole perception of the IP system is changing, we have seen, for instance, Tesla company, electric cars, protecting their inventions by patents, but then giving them out for free. So royalty-free licensing, they were allowing competitors to use their technology without being paid. And here you have some of the models of what we were talking, you know, how to share technology. But it's not that they did not patent. They patented it and then made this technology available licensing free. And this sharing with paying or without paying, because that's what we are talking about, you know, probably in the future proportion will be more in favor of free transfer of technology, but I doubt that the payment model will completely disappear. When we talk about types of licensing, it's very popular to talk about the plain vanilla licensing. That's like a ice cream flavor in the US, you know, the basic, and that the mechanism, the legal mechanism behind it is then relatively straightforward, and then we can add many other features on it. And what is so beautiful, if you will, with licensing is that really there is so many ways to regulate your relations between the parties of a licensing agreement. It is so open to imagination and to creativity in structuring this cooperation you are building. So don't be prisoners of models of plain vanilla licensing. Try to adjust it to your own needs, and especially because licensing in case of patents is sometimes very long term. If you license a product for 20 years, this means that your company is likely to live with that agreement even after you leave as a manager or change a company or something, you know. So this needs to be well thought and done in such a way that that parties can live with it, and not that they want to jump out of the licensing agreement. So it is good to spend time negotiating, getting to know each other, understanding the interests of each party, and this will result with a better licensing agreement, and it will be less plain vanilla. It will be more tailor-made for the parties in question. Then we also talk about compulsory licensing. This is when a party does not want to license, yet there is such an overwhelming public interest that the court may decide that there will be a compulsory license. This is not used very often. Now we were speaking about the exemptions to patents for the COVID purposes, but even without these exemptions, it would actually be possible to do compulsory licensing. Only the countries avoid compulsory licensing because it scares the investors in general. So you do compulsory licensing in IP, and the investors stop investing in your country. You know, so this was used less than originally contemplated. But keep in mind that it is always a possibility, and this is something like the expropriation in traditional property. When you build a highway and someone doesn't want to sell a lot of land, you can expropriate it, and that's the similar thing with compulsory licensing. When you have licensing in place, again, you need to monitor what's going on, assessing the situation. Over the time, things change very much, and something that was not too expensive in terms of licensing fee might become too burdensome in a more mature market after 10 years and things like that. So you do it before, you do it in the course of licensing, and you do it by the end as well, you know, because you want to preserve relations with the other party for the next round of licensing, let's say, based on another right.
I have a question.
Yes, go ahead. Yes.
Regarding compulsory licensing, when could this happen? Besides this case of vaccines, can you give us an example of when this happens?
But this can happen in the situation, as I said, of overwhelming public interest. So typically, this can health crisis could be a good example. No? So if someone doesn't want to make their patents available and charges exorbitantly or increases the prices during such a crisis, a country has a legal instrument, and many patent laws of national jurisdictions will have a provision that will allow a court to affirm the public interest and make a decision that there will be a compulsory licensing for a party. There are more and less developed compulsory licensing systems, and some of them even determine a rough idea of how the pricing will be set. Because this doesn't mean that it will be made for free, but there will be a reasonable licensing fee paid, just as in the case of expropriation. We don't expropriate the land of those people who don't want to sell for free. We establish the price which will be paid. No, so that's how the system works.
Okay, thank you.
Yes, and there were cases. Now I can't recall cases, like a case study when it was done, but it was done. And after the wars and things like that, people were going into compulsory licensing. But it is not very popular because, as I said, it kind of disrupts the investment climate. So we are not free to do in the IP whatever we think would be best. The policy makers have a more complex analysis before deciding what will they do. When we talk about types of licenses, we can look at this in different ways. And regarding the scope of licenses, we talk about the exclusive license when there is only the licensee. So the licensee can exclude even the licensor from practicing the invention in that case. So there will be only one licensee and he will be the only one practicing this. That's exclusive license. There are non-exclusive licenses where you have multiple recipients of the license and they will not be able to exclude each other. And then there is sole license, where we have a licensor plus one licensee. When we license one licensee and guarantee to them that we will not license the other multiple recipients of the technology. Then regarding the transferability, we talk about the transferable license, where the licensee can transfer the right to so-called sub-licensee. So we are talking about the sub-licenses. There we have non-transferable when excuse me, when there is no such right, and as I said, we talk about the sub-license in these cases. Then we regarding the direction of transfer, we talk about the licensing in when we are recipients of technology, or licensing out when we are allowing others to use the technology under that license. Then there are many other ways of managing the technology transfer, because when we are talking about the licensing, we are talking about technology transfer. There are such a way, like such instruments which are contractual instruments. This is built into the license agreements, where we have situation of cross-licensing, where we mutually license each other, or for instance, we talk about the pooling or grant back. Pooling is when everyone puts their own patents in a pool, and the members of a consortium, for instance, can all use their rights. Grant back is when you receive a license, but you accept the obligation to license with whatever you develop during the licensing agreement. So during the duration of license, you will be developing technology further, and you grant back the license to use these improvements to the original licensor. So it's a very, very flexible instrument. It can get quite complex. There are a lot of pricing issues that I am not talking about here. Very often, entrepreneurs ask lawyers about pricing, but we don't know the pricing. Every industry will have different systems of pricing. Also, there is some kind of a stigma attached to licensing, especially in less developed countries, where it is seen as an inferior position. This is conventionally considered not to be true. It is the funny thing is that you have more licensing in developed economies, because the people there understand better that a license is sometimes the cheapest way of getting the best technology without R&D costs. So you, instead of developing things that you need for your invention yourself, you are taking in existing pieces of technology and thereby speeding and making cheaper the development. In less developed countries, it's not so clear, and people have a feeling like they're in inferior position when they are licensing in. But it's not so, and it is important to understand. So don't be shy to license in. You know, just find the technology from other people. You know, it speeds up the exchange. And if you have to pay for it, then you'll pay for it, but it will still be cheaper than developing your own. And I said, it has the advantages for those who are licensing out, because they can monetize something that they are not even using. I mean, IBM, who was one of the biggest patent filers for decades, they had stables of tens of thousands of patents which they were not using, but they were still licensing them. So the stream of revenue is increased. The less used technologies get a chance to, you know, to be used. Development is at a lower cost, as I said. Normally, licensing also comes with the access to the markets, because you have a better product. You can tap into resources of your licensor sometimes and market together and things like that. So there are commercial advantages. You adapt faster to the market needs. You are there before your competitors with an improved product. And it has this modern magic where the competitor becomes really a collaborator. And we see this so often on the modern markets. I mean, this is really a feature of modern markets, and licensing is one of the instruments that bring us to that. Disadvantages, people tend to look for disadvantages, and obviously you can find disadvantages everywhere. Sometimes you will be making ultimately a greater profit rather if you accept sharing the profit of all your sales with the licensor. But it's not really often. Then for the point of view of licensor, it has been seen that the licensee can grow into a role of competitor after the license ends, for instance, or by learning about the technology and becoming really a more even player. Then if you do bad license agreements with unfavorable terms, then you are again, you know, a prisoner of a situation that is not beneficial for you commercially. So one must be careful what kind of an agreement are you concluding. And there is also has been noted that technological dependence of the licensees on the licensor can develop over time if you have a kind of lazy licensees who are not innovating for their own account. So we are looking into counterfeiting and piracy so that you understand that the right really lives not in the patent office. The IPR lives on the market. This is something that people also in less developed countries or even in the patent offices, the employees of patent offices don't understand that IPRs is not about granting a right. It's exploiting the right. So I included this primarily for this reason, to make it visible to you that in as much as it requires effort to obtain a patent or to obtain a trademark, which is less of an effort, but still, you know, the real effort, the real meaning of all this is to exploit it on the market. And when we talk about infringements to the IP rights, then we talk about the piracy in the case of software, primarily, and counterfeiting instead in the field of industrial property rights, especially trademarks. We have also business intelligence issues, such as connected to trade secrets. So we don't talk about the piracy of counterfeiting of trade secrets. We talk industrial espionage, if you want, which is a traditional name for business intelligence. You know, so business intelligence obviously being much broader, where you even by legal means do. But sometimes this is like a euphemism for industrial espionage. And then the patent infringement, which is an animal unto itself, and is really a complex legal situation always. There's no patent case that is simple. So anti-counterfeiting and anti-piracy combat requires constant escalation, because there's more of it. And here's the question again, philosophical, you know, are we doing things right with IP? Wouldn't it be better to share more or in a different ways? Who knows? These acronyms here are failed increases of legislative solutions. So these are failed proposals to make stricter regulation. SOPA and PIPA were in the United States, and they were both shot down in Congress. And ACTA was an international legal instrument, which, for instance, European Union acceded to. EU is a signatory together with the countries, but most of the member states did not ratify it because there was this backlash against the intellectual property 10 years ago. So these were failed attempts to escalate the legal protection. Yes, we will look a little bit about the practical aspect, and you know, because it requires such large resources, the question is ever more increasing. Can law continue being efficient? Is it becoming a burden to economy? You know, these are very big questions ahead of us, who's no one really daring to touch, you know. I can tell you, as someone who now has many decades of experience, I think that the entire idea that we have about the role of law in the countries that adhere to the rule of law. So we are not abandoning rule of law, but the role of law will change. And it will be much more marginal in the future, in my view, because it is so poorly designed for high-intensity interaction economies that we have built in the meantime. So yes, what I'm teaching you will produce billions still in the future, but we will have to come up with different solutions, just as a continuation of our, you know, of our discussion in the last block. Here you go. You all know this, you know. When I started anti-counterfeiting combat in mid-90s, we still had Italian counterfeits coming in. We have Turkish, you know, we have Italy has Asian from Morocco, from this, from there. But just showing how Italy switched as a EU country from having its own counterfeit industry. Today you don't have this anymore. I mean, I'm not saying absolutely you don't have it. You always will, but the things move a lot, and EU is an important player. And I mean, for instance, you know, the sport, the little pictures that nowadays we have Italian manufacturers complaining about the Croatian imitators. But before, there were Italian imitators of the Italian product that we were seizing here, and things like that. And when I spoke once to a colleague from Malta, he told me, "Oh, we are like Croatia. We are a transshipment, a transit country where the goods come, you know, and go to the other markets." And so I asked him, you mean the African goods destined to European Union and to Italy? I said, no, he says, the European goods going to Africa. So, you know, these things are widespread and very hard to stop. And it's you know, I ask sometimes my colleagues, are we doing the right thing in using law to stop counterfeiting? You know, how is it that after 30 years in the field, we keep saying that there's more and more of it, you know, and the measurements show there's more and more of it. So the law cannot resolve this, obviously. However, without law, there would be total disaster, no? Because we would be buying unsafe counterfeits of medicines and things like that, you know, that would be sold on our markets. So it's a rather complex thing to say. And obviously, before, especially in Italy, you remember all these blankets on the street, on the pavements, and beside the beaches, where you would have extracomunitari selling counterfeited leather goods, no? And then carabinieri would come and they would flee. You know, you would just see them taking the blankets and running away. And then there was this period when Italy introduced fines for people who were buying this. Probably someone of you remembers the situation in which this Danish tourist was fined 3,000 euro for buying a counterfeit bag, all in attempt to stop the counterfeits. Croatia also, here in the village on the island where I am, you know, last were around 6-7 years ago, there was a wave of fake sunglasses. You know, all the Luxottica brands were faked massively. And you could see that this is an organized crime thing, because you would see them repeating on every village on the island. You would have the same displays of the same counterfeit goods. And every country has its own problems in combating this, but brand owners were relying on the cooperation with the police. But what does it help? You know, here, when the police from Split goes on the ferry boat to make a seizure here on the island, you know, already people on the island are told that the police is coming. Croatia is small, everyone knows each other, you know, and they tell them, look, the police force of Split is coming to the island, and then they remove things. So it's a cat and mouse game with an incredible you know, effort and results that are in a way frustrating. I just want to point out, I worked a lot with Turkey also. Now, Turkey is a big counterfeit emitting country. And I've been there and talking to the police and like that. You learn incredible things. And I want to tell you about the different types of counterfeits. So in Istanbul, you have people who are counterfeiting Gucci and Fendi and Prada bags. But what they do is that they don't make a cheap knockoffs. They actually make a better product. And as artisans, they put incredible pride in that. So where you would have a gold-plated buckle, they put the real gold. They use even finer leather than it is used in the original. And they sell a bag that costs 3,000 euro for 9,000 euro to the different global celebrities. So you have all kinds of counterfeiting all over the world, from the worst, to these, from the worst the cheap knockoffs with the toxic components, and the sports shoes will sometimes contain toxic glues that your children will be putting on their feet, and when they sweat, this will enter into their bodies and things like that. This is why we fight this. So these products are dishonest. The misappropriation of the brand is dishonest in itself, and when it has this safety component, including the sunglasses, which can break in a way to damage your eye and things like that, or even simply let the rays, the sun rays into your eye in some distorted way and damage your vision. So there is this safety component and this dishonesty of using someone else's identity, which is what makes us. Here on the right we have the US, I think it's customs seizing products, and here you have them, and this is how it looked 15 years ago on the Italian beaches. And here on the right, you see the cosmetics, and the health products being with the health products. It's in the EU we have less, and Croatia, which is generally an over-regulated country, we have such a congestion of rules everywhere. But this helps us, for instance, to filter out, because the pharmaceutical channel is really tight, and it's not easy to place counterfeit goods in the pharmaceutical channel in Croatia and in the EU in general. But what happens if you have a fake which has no active compound? What if the active compound is in a different proportion, meaning too little or too much? What if there is another active compound that kills you? So these products are really dangerous, and it's really, now we had this with COVID vaccines again. You get a jab of a fake vaccine. You go out, you get COVID, and you get seriously ill or worse because of that fake. And someone made money on your illness. Here are some examples of Croatian. This upper two is a factory that was in northern Croatia that was doing this old model in Yugoslav times under a sub-licensing deal from a Slovenian company. But then they lost, both Slovenians, but they had the original molds and the know-how of how to do this. I think it's called the universal model, and they continue doing this universal model for years. And I always say we shouldn't be hiding the facts here. The director of the company was a brother of a member of parliament. And the police would come and nothing would happen. And the police would come again and nothing would happen. And we struggled to stop them. So you have different things that you have to face when you are trying to do the counterfeit. And I can tell you stories, just amazing stories from all over the world. Mexico, again, I said my wife's Argentinian. Stories from Latin America are beyond belief, really. What you hear, what is happening and then every sports championship has the uniforms, the sport uniforms counterfeiting, and there is a lot. I will not go now in the systems, how you practically stop this, how you mark them, how you trace what is counterfeit, what's original. This is a long story. I teach this at the University of Göttingen. I teach practical aspects of anti-counterfeiting combat, and I can give you like literally 4 days of these examples. But this is just out of curiosity, so that you see, you know, how far is law from really what is happening on the ground, and how complex then it is to apply law and get results. You know, that's a challenge. But in the end, we went through tons of, you know, counterfeited goods being destroyed. And people ask why to destroy them. Well, basically because they are potentially unsafe. You don't know if the glue that is used is toxic or not. And who is going to pay for a test whether the glue in a sports shoe is toxic or not? You know, the counterfeiter is somewhere halfway around the globe, and certainly not the brand owner is not going to pay for testing this good. So then when they are destroyed, this must be done in environmentally acceptable way. And we have big problems out of the most developed countries. And when where we have environmental protection, we destroy this by separating, you know, plastic and rubber and leather and paper and liquid, I don't know, counterfeited perfumes. You cannot just let this alcohol go into the environment. You have to separate the broken glass when you destroy it, and the liquid, and keep it in without spilling out. And less developed countries cannot do this. So you have people burning tons of plastic and rubber just because. So it's a huge civilizational effort and an issue, really, which goes into that. I just wanted you to have this idea. I have told you that patent enforcement is a game unto itself, and there is really very little similar to it in complexity. One of the common difficulties is lack of concentration in terms of jurisdiction. So for instance, in a developed country such as Switzerland, before the reform, there was a big problem that out of 26 cantons, only 4 had experience with patent litigation. So when you ended up in a court in a, you know, less industrialized canton, the judge there would have no previous patent experience, in spite being in one of the most developed countries in the world. And the countries did a big effort over the last couple of decades, including Italy, that introduced specialized IP courts. Italy was struggling with the reform of IP jurisdiction for many years, and was not satisfied with the results. And then by introducing the specialized IP courts that do only IP, suddenly the results were there. So Croatia has traditionally 4 courts of our strange shape. You know, we have, it's not practical to have only court in Zagreb, although our size would, you know, say Albania did only court in Tirana. Only Tirana deals with patents in the entire country. And then this gets even more complicated because what I'm talking is a civil jurisdiction. But when you have a criminal protection, which is not so often for patents, but still, if you have criminal protection, I mean, but even for trademarks, then this will come. There is no specialization for criminal courts in most countries in the world. So it gets, every time a trademark case gets to a judge, it will get to any little court in a small town in a country, And the judge is most likely to have always, again and again, first ever case in trademarks that she or he ever had. The things that you see in the courtrooms, in these provincial courts, when you use criminal protection, just I had a judge who allowed the prosecutor to call me as a witness. I mean, this is already unusual, you know, because I started the procedure by representing the injured party. And you don't call a representative of injured party as a witness on factual, but it happened 3 or 4 times out of sheer desperation that the small town prosecutor didn't know what to do with intellectual property case. So he called me as a witness, but what he actually wanted is to have an expert in IP law in the courtroom. So he actually called me as an expert for law rather than a witness. And so they examined me and cross-examined me, you know, and after 40 minutes, the judge goes like this, you know, kind of thinking. So he says, but does that mean that no one else in Croatia can put 3 stripes on a sports shoe? And I said, yes, Your Honor, that's the intention of the legislator. So the judge, if I wouldn't have been there, who knows which conclusion would he have? And this is just because I don't want you to think that our systems really work. You have incredible situations all the time, and we who invent need to be prepared to know what is going to happen during the life of exploitation of the intellectual property we contribute to. I know it's a big task. It's a lot on the plate for any one of us, but that's what our cultures after 300 years of using intangible assets still need to accept, and especially because the digitalization made it even more complex and things are sold without us seeing them being sold. Of course, it is easier to survey because you can do it centrally. You don't have to go from New York to a small town in Croatia to see what's happening on the local market. You just sit beside the computer and survey all the world. So it all goes in ups and downs for the brand owners. There are advantages and disadvantages, and we are struggling with increased number of counterfeits without real hope that this will change in foreseeable future.
So may I ask something? Sorry.
Sure.
Who initiates those actions of discovering which goods are fake? The companies like Adidas, Nike, or the governments?
Yeah, both.
So when some good comes in Croatia from, I don't know, China. Okay.
Yes, when I teach enforcement, I have a separate block on this with few slides, which are fairly elaborated in the sense that I show all stakeholders and all the components of a typical system in any country in the world. Let's say ideal system. An ideal system is always too complex. Croatia is a good example. We have such a complex system for a small country that it's hard. There is always overlap of who will do what. You know, it can be started by police, by public prosecutors, by the brand owner, by a association, industrial association of players. In different circumstances, different people can start the procedures. Normally, the companies, you know, part of the price, when you pay €100 a sports shoe, you know, I think that 20 of that goes, I'm guessing, you know, it's not serious, but 20 goes to the enforcement, you know. The other 20 goes to research and development. So these prices are not totally invented. There is a bigger premium, but the cost of running a brand in good order is enormous. And I used to travel a lot before pandemic and before I was ill with this thing, which I had viral myocarditis 3 years ago. And then I was sure, as I knew, that on 50% of the flights which I took all over the world, you know, from Australia to Argentina and from China, you know, to Morocco, I am sure that on 50% of flights there was sitting in the same plane someone who was either a private investigator working for a company or some in-house person who would be you know, also part of the monitoring effort of what is going on the market and things like that. So this is just gigantic structure of taking care of the, and then normally they would use in foreign countries, they would use attorneys, local lawyers to start a procedure rather than doing them themselves. Any kind of the procedure, administrative, civil law, criminal law, or misdemeanor procedure. And then on some instances, Croatia, for instance, at the time when we were joining the EU, we wanted to show how our ex officio actions are, you know, frequent, and our police around 2013, or when did we join? No, was it 2013 when we joined the EU? Around that time, there was a lot of police actions ex officio. When we entered the EU, then this dropped significantly. And we had problems almost bigger than before, you know, in starting the actions ex officio. And things like that, you know, I can really teach about this for days, so let's not go too deep. Any other question about that? No? Then let's move on. I'm not going into the legal content of these slides. As I said, you know, this is not the intention. One thing I need to tell you, which is very important in intellectual property context, and so it is in patent litigation, and that is, how to put it, let's say, unproportional importance of interim measures. So interim measures are always very powerful because you get them before getting the decision on the merits of a case. But in intellectual property cases, it is almost as if 80% of the cases will go only after interim measures, only asking for interim measure. If you get an injunction, rights holders will lose interest to conduct further proceedings, and they don't even, very often, most often, they don't even ask for damages, because damages will add another year or two to the length of the court proceedings, and they're very hard to establish. There are no universally accepted methods for establishing damages in intellectual property infringement, and small countries have especially a lack of guidance in this sense. So you will have the owners who will only want success with an injunction, stopping the infringement, and then doing as the least effort with the legal proceeding afterwards. This is why they were, since the 90s and early 2000, so much using the criminal protection. Criminal protection was not traditionally used in intellectual property, but then it had a big increase, and that was exactly because of this increase of ex officio actions. More and more countries started giving their enforcement agencies more right to act on the official basis. And that decreased the costs. But after some 10, 15 years of doing this, then the countries started scratching their head and said, well, we are paying so much for this, what are private rights, essentially, you know. And there was kind of a backlash. So today it's not as good as it was. But in the meantime, the customs, which especially in European Union was losing its importance because we had customs only on external borders and not within the EU. So we had other custom resources which we could have trained and used for IP combat, the IP counterfeiting combat. So the customs got an increase of importance, and they are doing it also both on ex officio basis and on a registration basis, where the rights holder register their rights with customs, and then they do it on their own initiative. Customs do it ex officio based on this registration. This is quite efficient. And then you can always obviously notify customs about counterfeits even without being registered, but then you have a problem with short terms because customs seizures and customs enforcement in general is made so not to slow down the flow of global trade. Global trade, the speed and ease of global trade is a value per se, and not even intellectual property was considered sufficient enough. So the terms of holding goods that are allegedly counterfeit are relatively short, 3 days extended to 10 days. Sometimes this is not sufficient to determine whether they are counterfeit or not, and they are released because or not slowing down the global trade. So we have this balance of interest in the customs procedures, which are, but still it is a very efficient, and you can see here societies using less law in traditional sense and using something that almost can be said is semi-automatic and much cheaper than conducting a full IP litigation in a civil law court, commercial court in some country. With patent litigation, these semi-automatic things are not used because patents are so complex to determine. And, you know, even for instance, criminal law protection of patent is not really done even in the countries that have criminal acts against patents, because patent can be cancelled. And in civil proceeding, they are very often cancelled. In the UK, there was a period some 25 years ago that when you would have a patent litigation in court, more than 50% of the patents were cancelled. So they were not valid anymore. This dropped with years, and now there's much less, but it shows you the risk of putting someone in jail for patent infringement for a patent that is later on cancelled. Because when you attack it, then it will be re-examined for various reasons and it can be cancelled. So you don't do criminal enforcement of patents as a general rule, obviously, unless there is some criminal or organized crime of high degree, you know, very high degree of criminal intent, and then might be, but I'm not aware of ever conducting a patent case through criminal system. And again, I repeat, because in most of the countries, it's not in the criminal law at all. So for patents, you would still rely on an interim measure. And again, in Croatia, we do have problem with that. We even ended, before we were in the EU, we ended up on the American list called Special 301. That's the US Trade Representative making a list of the countries, putting countries on the observation watch list, so-called, for some deficiencies in IP system. And Europe does this as well. We have a third country report by European Commission, which is published every 2 or 3 years. And we do the same with other countries. Mostly these are the same countries on the American and the EU list. And Croatia ended up because of the slowness of patent injunction procedures. And why were we so slow? I mean, first, our court system was not very fast generally, but the judges were so inexperienced that they were even much slower with patents. Plus, they were so impressed by the technical aspects of patents and the huge values attached to the products that contain this invention that they were reluctant to issue interim measures. So they were using different procedural reasons to postpone. And you would wait for instead of, I don't know, a week, which would be a desirable average of the European Union, which goes from 24 hours or 3 days on the very fast end to 3 weeks on the slow end between the member states, you would wait for 1.5 years. You know, so that is a problem in itself, and it did not go away, I am afraid. I was involved in most of patent litigation in Croatia, just because we don't have so many, and my partners and myself are very often a destination for patent cases in Croatia, so we were often involved, and this slowness and reluctance to decide is still part of the system, unfortunately. But theoretically, the courts in Croatia, like in all countries that are part of TRIPS agreement, they can do this inaudita altera parte proceedings, where you don't have a hearing with the other side. The court decides based on only one party. If you make certain things probable, then the court will issue an interim measure. So this has happened. I had this in designs and trademarks, not in patent, I think, so far. But these are possibilities, and they should be used. And you may want to keep in mind that these are things. And in Italy, I also lost track over the last decade what was going on before I knew, because I was more in contact. So this I have actually covered. Yes, as I said, Croatian system is overly complex. European Union noticed this. They have advised us to streamline. The misdemeanors were overlapping even with criminal and civil. So you would have the same behavior that would be civil liability, criminal, and misdemeanor liability. I mean, that's a chaos. And then we did it, we split this in a way so that there would be just a misdemeanor, just criminal, just civil. But then it didn't work that well. Our public prosecutors were finding way not to prosecute IP because they were not feeling confident in doing that by using these splits that were introduced. So long story and very legal one. And you know, if I go in that, we all go out with the head spinning even more than from the patent granting procedure, because this is also quite fine details here. And yes, customs, they are used, as I said, increasingly, and they are the way to go. You know, Italy had very good systems there. The Fiamme Gialle, no, the Guardia di Finanza was one of the efficient European enforcement agencies, had a program before the common European infringement database, had an Italian database. I forgot now, it had some acronyms. Italy has a love for acronyms. I forgot now what was this. This has been discontinued, but it was an impressive, it was like a database of stakeholders and the infringers and the instances of the cases that were started. So you could see who was involved, how was it involved, and things like that. And now this is done on the European level by the EU IPO, that's European Intellectual Property Office Observatory, which is an institution in Alicante in Spain. And it is also on a very high level. This is a good example of the EU global excellence. You know, these are some of the best intergovernmental cooperation examples anywhere in the world, which is not strange because EU is so much more integrated than anyone else is. No? So we are sharing data and everything almost as if it would be one jurisdiction, because it is one market. No? So we have this good results there, better than the others. And so that's the yes. As I had a lot of contacts with Italy, I inscribed myself into the Italian database, because I told them, look, I worked on many different Italian cases, and this Ufficiale, who was the anti-counterfeiting and intellectual property fair, he was not sure what would the regulation be, but I sounded convincing, and he put me into the database. But the EU IPO would not allow me the access. I think they have me anyway in the database because I'm a registered European trademark representative. But I could not, I tried to gain access, which actually I didn't gain even in the Italian case. No, I just had this possibility to talk about it. But in the European database, the representatives are not part of those who have access, but the owners of the rights and the enforcement agencies, so that they can share openly the information in a way where you don't want too many eyes. Because as a representative, I might be working for another industry, you know, and I might have access to sales volumes and counterfeiting volumes that not necessarily even my client wants me to know. So this is the reason why there are these limits. So what remains as a challenge is lack of infrastructure. Even in the most developed countries, we all the time have to keep up with the new situation on the markets. And the digital thing did not make this easier. So we have to build our systems, IP protection systems, infrastructure on a daily basis. It's just an ongoing thing. It never stops. We need to give equipment and education. And if you look the problems that Croatia had at the period of joining, you know, for instance, the port of Rijeka gets X-ray scanner that looks into containers without opening it. I mean, you wouldn't believe, but in 3 months, counterfeiters learned that Rijeka has a X-ray scanner and started routing counterfeits through Split. When Split caught up and got the equipment, suddenly they went to port of Ploče. When Ploče was beefed up and the people were trained, they started even using a passenger port of Dubrovnik. And so they just go around, you know, and the free trade zones in the world are used for counterfeiting, and all the weaknesses are exploited. And if you add organized crime to this, and I'm not going into story, you know, of the ports in Calabria and things like that, you know, what's happening there. You can never stop the gap, you know, education and equipment might not be enough, you know. There are other factors at play why we cannot achieve the efficiency we need. And the last but not least, yes, I will quickly just mention you, yes, then there are disputes between the right owners. And what I want to say here only one thing. I don't want to develop the legal content here. It's not about, I just want to tell you that sophisticated users of legal system stopped using legal system for the disputes between legitimate players. So you don't start a litigation of your competitor who is a legitimate business entity. You will do that only for criminal infringement. What you do on the legitimate side is you used so-called interest-based dispute resolution methods, meaning that you seek solutions based on interest of both parties. So this means in practice negotiations, facilitated or moderated negotiation, mediation, early neutral evaluation, and MEDARB, that's mediation and arbitration. And then you have the traditional position-based being synonymous for legal, because you have legal position. So you use the position-based dispute resolution methods for, and the methods are litigation, arbitration, for which it's important to understand that arbitration uses law. Very often, arbitration is put into alternative dispute resolution together with interest-based methods, but this just muddies the water. And even lawyers don't understand that arbitration is not the ADR in the sense of interest-based resolution, but it is actually a position-based dispute resolution methods, such as is ARB-MED. I will not go into details between these two. This is another separate course. Of course, I'm trainer of mediation, so I do this on Friday this week. Whoever wants to have training in Croatian, probably there is 1 or 2 places left for 5-day training in interest-based dispute resolution methods at the Croatian Mediation Association, where we hold this. There are then administrative, I said, misdemeanor, proceeding, criminal. So these are all different methods that we are using. Here is the one of those slides from the stakeholder parts, and these are components of a system that is duly equipped. You have national and regional IP offices, you have courts and tribunals, you have dispute resolution centers for mediation and things like that. You have administrative oversight agencies, which in former Yugoslav countries, we call them inspectorates. But in the UK, you have something called trading standards. In Italy, there are different agricultural and regional inspections who have authority. I had a case with the wine bottle wine in Alba, because this Croatian wine was called Alba, and then there's one of those inspection agencies, which was neither customs. I don't think I even understood who they were, but they intervened. Then you have police, you have customs, or Guardia di Finanza, depending on the country, you know, there will be some specifics. You have public prosecutors, sometimes even competition agencies have some IP jurisdiction. There will be people from internal corporate control and monitoring, which we called in anti-counterfeiting, we call this effort policing. So there will be different policing experts. There will be, like, you know, 5 different positions within a company that will have something to do. There will be external private investigators, lawyers, and IP representatives. As someone who is here, I go about the policing, but this is more about the trademarks. And as we are running out of time, I will end here and not do this, but take your questions really in this last few minutes. Thank you very much for your attention these days. It was my great pleasure. I hope that at least some of this will be useful. I tried to give you broad overview of this, what is the IP protection system, including the enforcement, as you have seen. And I hope, as I repeat myself, that some of this at least will be useful. Thank you very much.
Thank you, Mladen. Thank you also for bridging the Croatian part with the Italian part, with also speaking quite frequently also in Italian, for giving us, let's say, a more, how can I say, vivid representation of these processes. Personally, I don't have questions, because this last part was really a little bit far, let's say, from my research interests and also my daily, say, research activity. But of course, it is always interesting to learn something new.
Yes. Yes, it was a great privilege for me. Thank you, Guido, and also thank you for serving as a bridge between our two countries, which is so appropriate for someone in Trieste. But you know, it was a big personal privilege for me, because I am so connected with the two countries that I love so much, and you know, I would be even happier to share now with a glass of wine, you know, the things that we still have to learn about each other. It's an amazing thing that such countries that share a history, and not always easy history, but very deeply, you know, from times of Roman Empire. We share the history, yet we know so little about each other. And again, Veneti and Romagnoli know a little bit more. You know, I know enough how this is distributed in Italy, but generally we know little. And I know how my countrymen also don't really know the depth and complexity of Italy. And it would be so nice that we, so being part of this project that bridges the two countries, and was for me a personal pleasure of the highest order.
To me as well. I just sent you a request of contacting LinkedIn, so.
Thank you. I will gladly accept it. I have a mediation, online mediation now, so I will not go on LinkedIn now, but I'm starting in 10 minutes. So we'll be in touch hopefully, and again, if you need any further clarification about what I was talking, feel free to look for me either through this email here or through LinkedIn, or in whichever way you wish. I will be happy to help. Okay.
Thank you very much.
Thank you very much.
Thank you very
Thank you
much.
very much.
Thank you very much.
Pleasure.
Bye.
Bye bye.
Bye.
Thank you. Bye.
Yeah.
Bye.
Ciao.
Bye.